appellants in the Building Bridges Initiative Appeal case at the Supreme Court, including the Attorney General and the Independent Electoral and Boundaries Commission, have asked the Supreme Court to overturn the judgment of both the High Court and Court of Appeal that termed the BBI process unconstitutional. However, respondents in the case dismissed the petitioner's submissions, urging the 7-judge bench to uphold the decision of the lower courts. NTV's Setolale followed day one proceedings of the BBI Appeal case at the Supreme Court and files this story.
The 3-day hearing of the Building Bridges Initiative Appeal case at the Supreme Court formally commenced before a 7-judge bench presided over by Chief Justice Martha Koome.
The Honorable Court.
The main appellants in the case, that include the Attorney General and Independent Electoral and Boundaries Commission, were the first on cue, urging the Superior Court to quash the judgment of the lower courts that dismissed the Constitution of Kenya Amendment Bill 2020, terming it unconstitutional. Solicitor General Kennedy Ogeto, representing the AG, argued that the basic doctrine structure of the current constitution is amendable and that the president is immune from a civil trial while in office.
Where a constitution creates an amendment power that is similar to the exercise of the primary constituent power by being inclusive, deliberative, and democratic, such as is the case in our constitution, the basic structure doctrine has no place.
Former Attorney General Githu Muigai, representing the Independent Electoral and Boundaries Commission, stated that the IEBC was properly constituted to carry out the BBI process since it has a minimum required quorum of 3 commissioners. The former AG further argued that the electoral body enjoys independence from judicial review.
IEBC was always properly constituted. It had the quorum mandated by the Constitution itself. And there can be no higher law than the Constitution itself. The High Court and the Court of Appeal were in error.
The appellants were supported by the respondents in the case, that include the BBI Secretariat, President Uhuru Kenyatta, ODM leader Raila Odinga, the Speakers of Parliament, and lawyer Felista Wakesho.
Any steps taken prematurely to interfere with the exercise of that sovereign authority, I think that would be a case of judicial overreach.
However, respondents in the case led by Clarence Eboso, representing a lobby group called Hope 254, asked the 7-judge bench to reject latest attempts of changing the constitution and procedural.
We cannot have a constitution where it is changed every other day by whimsical feelings of the time. And constitutions the world over have a procedure that tends to make the process of changing the constitution unlike that of changing any other law.
The 3-day oral submissions will tackle 7 key issues that include whether the basic structure doctrine is applicable in Kenya, and if so, the extent of its application, whether the president can initiate amendments to the constitution, whether a constitutional amendment can only be initiated by parliament through a parliamentary initiative of the constitution or through a popular initiative, whether the second schedule to the Constitution of Kenya Amendment Bill 2020 was unconstitutional, whether civil proceedings can be instituted against the president or a person performing the functions of the office of the president during his or her tenure in office, the role of IEBC in the Constitution, and whether there was public participation while constituting the Kenya Amendment Bill 2020. The BBI appeal case at the Supreme Court enters day 2 on Wednesday with a host of respondents led by the LSK chairperson Nelson Harvey giving their oral submission before the 7-judge bench. Seth Olale, NTV at the Supreme Court, Nairobi County.